A very good day to you, Mr. Roland. My name is Mann Heyy. Today, I'm recording this radio presentation in order for you to have a better understanding of the relevant law that will probably be applicable on your matters with Ricky, and also giving some of the possible outcomes of the challenges that I firmly believe you will probably face. Mr. Roland, I will now provide several challenges that I have anticipated that you are probably going to face. First of all, whether the agreement between you and Ricky is a valid lease from the very outset. Now, what does it mean? It essentially means that whether the agreement between you and Ricky has met the requirements set out by the House of Lords in the case of Street and Mumford 1985 of forming a lease. And provided that the agreement between you and Ricky is a valid lease, is it a legal lease or an equitable lease? And provided that it is an equitable lease, whether Mr. Roland and you can still enforce the lease. Now, this may sound a little bit difficult to understand on a lot of the jargons in there, but it doesn't matter. It only very important for Mr. Roland to understand is that the main issue between you and Ricky is revolving around the enforceability of the lease. If the lease is enforceable and you both are bound to honor this agreement, then a lot of issues is going to solve. It's not a big issue at all. But before going in that, of course, I have to first inform Mr. Roland, since the facts provided here are a little bit unclear, whether the land, which means the workshop that you have rented to Ricky, whether it is registered or not is unclear. But since now it's already 2023, and due to the natural effect of the Land Registration Act 2002, which extends the circumstances of necessary registration, therefore this whole presentation will be based on the assumption that the workshop, has already been registered at the registrations. Mr. Roland, I will now move on to the first and the most fundamental issue of the case, which is whether the agreement between you and Ricky is a valid lease from the very outset. In this regard, I would like to cite the case of Street against Mumford in 1985, where the House of Lords has set out 3 requirements of forming a lease. This includes the tenant must have an exclusive possessions, and there must be a determinate period, or sometimes referred to as a certain term in the lease itself, and there's a rent that's payable by the tenants. Now, I will now first address the first requirement, which is the exclusive possession. To determine whether the tenants have an exclusive possession, it will be a matter of facts. So exclusive possession essentially means that whether the tenants has the right to resist anyone, most importantly, including the landlord, which is Mr. Roland in this case, from going on to the land. But provided that, given the circumstances of the scenario, it is unclear whether Ricky, the tenant, has the right to exclude the landlord, which is Mr. Roland, from going onto the land. But at the same time, there's also no indication that Mr. Roland, the landlord, have ever gone into on the premises, the workshop that got rented to Ricky, without the permission of Ricky. And even if we look into the agreement, the term of the agreement, it also does not provide anything like the tenant doesn't have the exclusive possession right, or the landlord, Mr. Roland, can go in anytime as he wants. It doesn't provide it. So even if it is a matter of fact, but even if we look into the terms of the agreement, it still shows that the tenant seems to have the exclusive possessions. And for the second requirement, now a lease can only exist if there's a certain term, or sometimes referred to as a determinate period. But I prefer to call it as a certain term because it's I think it's an easier way to understand. That tells the certain term is essentially something in the lease itself that tells the party the duration of the lease, like when it will be terminated, or in other words, when it will be ended. So this requirement is essential. And I firmly believe that Ricky will argue on this point to say that this lease is not even valid due to the lack of certain term that's stated when the lease is going to be or when is the lease is going to be terminated. However, if we look into the facts carefully, there's actually a determinate period or a certain term in the lease that tells us the duration of the lease. Now, although it is not expressly stated, but it can be construed by understanding the case of Prudential Assurance Company Limited against the London Residuary Body 1992, where the House of Lords held that a yearly tenancy was created on the land. In that case, in the Prudential case, it was a yearly tenancy created on the land by virtue of the tenant had entered pursuant to the agreement on a yearly payment rent. Therefore, the lease was then a term certain. Now, what does this mean? To better understand this, it will now lead us to the classification of leases. There are several types of leases, but in this case, the lease between you and Ricky is a periodic lease, or specifically, it is a yearly periodic lease, which means the lease exists on a year-to-year basis. Why is that so? This is mainly because the agreement between you and Ricky itself had clearly stated the rent will be payable 1 year in advance, which makes it falls under the category of a yearly periodic lease. And according to the Prudential case, as I mentioned earlier, it forms a certain term. Now, last but not least, let us move to the last requirement of a valid lease, which is a rent. Now, a rent in the case of straight amount, but the Lord Templeman, one of the judges in the House of Lords, it says that it is necessary elements. But however, the Court of Appeal later on in 1989, in the case of Ashburn Ulster against Arnold, have confirmed that rent is not necessary. But whether or not it is necessary, it does not matter anymore, because in this case, there is a rent payable by the tenant, which is Ricky, although it does not pay the full amount of it. But since it already paid the amount that is equivalent to 5 months, and you, Mr. Roden, have accepted it, therefore the rent requirements has also been satisfied. So looking up all these requirements, it can be easily tell that there is a valid lease between you and Ricky. Now, Mr. Roland, provided that there is a valid lease between you and Ricky, that's not the end of the story to tell. I'm so sorry to tell that, because another issue arises. Is whether the lease between you and Ricky is a legal lease or an equitable lease. Now, this make not really much of a difference in the sense of protection, but it still make a difference. Now, because of the facts have clearly stated that the lease between you and Ricky has never been formalized. And when a lease says to be not formalized, it essentially means that it does not execute as a deed. And whenever, generally speaking, whenever that the lease is not executed as a deed, then it will generally fall under the category of equitable lease. Because informally, equitable lease, this is a general idea. But in this case, it does not necessarily to be, because under Section 54, subsection 2 of the Law of Property Act 1925, it gives out an exceptions where an informal lease can also be a legal lease if it met with the two requirements. First one, the tenants had taken effect in possession of the premises. Second, there's a rent payable by the tenant as best rent. Now, let me first address the first requirement here, the taken effect in possession. So the tenant has to take effect in possession of the property. So, but there must be a duration, right? You cannot say that, like for example, the lease was like 5 years and it only taken effect 4 years after the lease have executed. That doesn't make sense. So in this case, I would like to cite the case of Long against Tower Hamlets Borough Council 1998, where the court held that a lease will fall within this short lease exemption, which is the Section 54, subsection 2, as I mentioned earlier, and be legal if the tenants for entitlement to take up possessions arose at any time within 3 months of the date of signing the tenancy. Now, given the circumstances of the scenario, it is at the same time it is very unclear whether the Ricky have actually get into the premises within 3 months. But the fact that Mr. Roland Yu allowed Ricky to move into the premises after he paid the rent, which is equivalent to 5 months, and Mr. Roland Yu again wants Ricky to honor the agreement and pay the remaining 7 months rent in advance or leave the property, indicates that Ricky's is actually taken effect in possession of the property right after he paid and continuing to stay there for his motorcycle business. Further, the second requirement is the rent must be payable at best rent. Well, the first best rent here is still a little bit unclear even in nowadays law, but we may also construe it by looking into the case of Fritz Christen LLP against Panayi 2008 and Law Fields Limited against Law Harbour Commissioners 2008, where the best rent may mean a rent at market value or above, but presumably it's not going to be below the market price. As I mentioned earlier, the agreement itself only stated that the rent needed to be paid 1 year in advance. No prices was specified. Therefore, the requirement in some sense, like assuming that the rent in the lease between you and Ricky is higher than the market price, then under Section 54(2) of the Law of Property Act, it will confer the lease between you and Ricky a legal status. However, as you can tell, it is a little bit argumentative to say that it met the requirements because, again, the facts provided here is very limited and unclear. We cannot 100% assure that this is he has met the requirement of a legal lease. So I think it is more appropriate to assume that this is an equitable lease. Now, what's an equitable lease? Now, when a lease is not recognized as a legal lease, it doesn't necessarily mean that this legal lease has no legal effect at all. In other words, in the other way around, equity may now step into play to recognize this lease as an equitable lease. Now, at this context, I think it's very important for me to explain what is equity and what is common law, the difference. Now, I would like to draw your attention to the burger and slices here. As you can tell, common law is like the bread, like the cheese, like the meat, like tomato of the burger. It plays a very important role of the burger. The most important role. Improve the texture, make the burger look nice. So equity is just like a piece of vegetable. It's not a necessary element, but it is there to fill in the gap and to make it look more colorful, looks more nicer. Without the piece of vegetable, it can still be a very good burger. But with the piece of vegetable in the burger, it will look a lot nicer, and sometimes for vegetarian that will just like it. They'll just love it. So the idea of equity is not a like a new law to take over the common law. It is something that to fill in the gap of the common law. Because the common law is strict, it only recognizes the kind of interest. And equity is some kind of law that will come into play to recognize the interest or some of the like a lease that is not recognized by the common law. So to ensure that everybody's interests get protected. Mr. Rowland, after discussing all the equitable lease, the legal lease, I think it's a very good timing for us to now come to the very fundamental issue here, which is the enforceability of the lease. Now, provided that it is an equitable lease, does it mean it has no legal effect as a legal lease at all? No. In fact, it is the other way around. Whenever there's a conflict between the common law and equity, equity will prevail. To understand this, we may now look into the case of Wash and Lonsdale 1882. In this case, it set up a precedent that equity actually enabled a landlord to enforce a term of a lease with the tenants, despite that the lease not being formalized, because the court held that an equitable lease is treated at law as being as good as a lease, which means even if it is an equitable lease, it will still be capable of binding to both parties, just like a legal lease. But however, due to the development of the law, this doctrine was further enunciated. It will be applied where the contract underlying the informal lease, like this case, complies with the Law of Property Miscellaneous Provisions Act 1989. And in Section 2, Subsection 1 of this Act, a contract of disposition of interest needs to be in writing, it contains all the express terms, and is signed by both parties and provide for considerations, and it will be specifically enforceable. On the facts, it is crystal clear that the lease between you and Ricky was in writing, it contains all the expressions, and eventually signed by both parties. Therefore, this doctrine where the equitable lease has the same effect as the legal lease does apply to the lease between you and Ricky, hence it is enforceable. Conclusion, I would like to now summarize the issue that we have been covered earlier. First of all, whether the agreement between you and Ricky is a valid lease from the very outset. Yes, it did, because it does met the requirement set up by the House of Lords in the case of Strait and Montfort. And the second one, whether since it is a legal lease, whether it a valid lease, whether it is a legal lease or an equitable lease. In this context, more facts needed. The facts provided here is very limited, and I cannot 100% assure to you that whether this is a legal lease or an equitable lease. But either one of those, whether it is a legal lease or equitable lease, they have the same legal effect according to the authority of Wash and Lonsdale and the Law of Property Miscellaneous Provisions Act 1989. Once again, thank you very much, Mr. Roland, for using your time to watch these presentations. And this is the references that I have been referred to in order to prepare for these presentations. One more time, thank you very much, Mr. Roland.